Assalamu alaikum. Hello to everyone. My students, this lecture is the continuation of the previous lectures, which are already uploaded in my channel, and this is the last part of our lecture, which is regarding the International Criminal Court, ICC, the court. In this lecture, students, I'm going to deliver my lecture regarding the how does ICC operates and the member states, and as well as in the last conclusion part, I will discuss the two cases, and thereafter selective articles of the Rome Statutes. So here is the I'm going to share with you. So students, this is the today's lecture, and how does which is the title of today's lecture is that the title of today's lecture is that the International Criminal Court, and the topic of that lecture, how does ICC operates. So in this lecture, I'm going to delivering my lecture regarding the how does the ICC operates. So these are the parts of this lecture. These are the topics which we are going to cover under the this title. So students, how does the ICC operates? Number one, referrals, analysis, and investigation. So initially, how do cases come before the court? Any state party to the Rome Statute can request the office of the prosecutor to carry out an investigation. A state. So students, I'm beginning with this lecture with the discussion on the how does the ICC operate. So in first part, referrals, analysis, and investigations. So how does cases come before the court? Any state party to the Rome Statute can request to the office of the prosecutor to carry out an investigation. A state not party to the statute can also accept the jurisdiction of the ICC with respect to crimes committed in its territory or by or by one of its nationals, and request the office of the prosecutor to carry out an investigation. The United Nations Security Council may also refer a situation to the court. So, can the prosecutor decide on his own initiative to open an investigation? Yes. If the office of the prosecutor receives reliable information about crimes involving nationals of the state party or of the state which has accepted the jurisdiction of the ICC, or about crimes committed in the territory of such a state, and concludes that there is a reasonable basis to proceed with an investigation, such information can be provided by the individuals, intergovernmental or non-governmental organizations, or any other reliable sources. The prosecution must, however, obtain permission from the pretrial chamber judges before initiating an investigation under such circumstances. So what happens when a situation is referred to the ICC for investigation? The prosecutor determines whether, in his or her opinion, the court has jurisdiction with respect to the alleged crimes. So, following a thorough analysis of available information, the prosecution decides whether there is a reasonable basis to proceed with an investigation. Therefore, it must establish whether the crime of genocide, crime against humanity, or war crimes may have been committed. And if so, whether they were committed after 1st July 2002. The prosecution must also ascertain whether any national authorities are conducting a genuine investigation or trial of the alleged perpetrators of the crimes. Lastly, it must notify the states parties and other states which may have jurisdiction of its intention to initiate an investigation. How is an investigation conducted? Students, how ICC will conduct the investigation? Um, the Office of the Prosecutor sends its investigator to collect evidence in areas where crimes are alleged to have been committed. The investigator must be careful not to create any risks to the victims and witnesses. The Office of the Prosecutor also requests the cooperation and assistance of states and international organizations. The investigators look for evidence of a suspect's guilt or innocence. So it was students. It was the first topic referrals, analysis, and thereafter investigations. So next topic of then after investigation, how arrest. This is second topic. How arrest will be made. Who has the power to issue a warrant of the arrest or someone to the appear? How ICC court will arrest the suspects or issue the summons? After the initiation of an investigation, only a pretrial chamber may, at the request of the prosecution, issue a warrant of the arrest or summon to appear if there are reasonable grounds to believe that the person concerned has committed a crime within the ICC jurisdiction. What information do the judges need from the prosecution before they can issue a warrant of arrest or summons to appear? When the prosecution requests to the issuance of the warrant of the arrest or summons to appear, it must provide the judges with the following information. These are the information: the name of the person, a description of a crime the person is believed to have committed, a concise summary of the facts, a summary of the evidence against the person, the reason why the prosecution believes that it is necessary to arrest that person. So these are the reasons on which arrest warrant would be issued. The judge will issue a warrant of arrest if it appears necessary to ensure that the person will actually appear at trial, that he or she will not obstruct or endanger the investigation or the court's proceedings, or to prevent the persons from continuing to commit crimes. After issuing warrant, what will happen? The registrar transmits request for cooperation seeking the arrest and the surrender of the suspect to the relevant state or to other states depending on the decision of the judges in each case. And once the person is arrested and the court is so informed, the court ensures that the person receive a copy of the warrant of the arrest in a language which he or she fully understands and speaks. Question is appear in our minds whether the ICC have a power to arrest the suspect. The court does not have its own police force. Accordingly, it relies on the state's cooperation, which is essential to the arrest and surrender of suspects. According to Rome Statute, state parties shall cooperate fully with the court in its investigation and prosecution of the crimes within the jurisdiction of the court. Next topic is the after the arrest, what will be the rights of the suspect? Students are detainee deemed to have been convicted by virtue of their transfer to the court? No. Everyone is presumed innocent until proven guilty before the court. The prosecution must prove the guilt of the suspect, and trial chamber will convict someone only if it is satisfied that charges have been proven beyond the reasonable doubt. So these are the rights of the suspects. Suspects are presumed innocent. They are present in the courtroom during the trial, and they have a right to a public, fair, and impartial hearing of their case. To this end, a series of guarantees are set out in the court's legal document, including the following rights to mention but few. Number one, to be defended by the counsel or of their choice, present evidence and witnesses of their own, and use a language which they fully understand and speak. Number two, to be informed in detail of the charges in a language which they fully understand and speak. Number three, to have adequate time and facilities for the preparation of a defense, and to communicate freely and in a confidence with counsel. Number five, to be tried without undue delay. Number six, not to be compelled to testify or to confess guilt and to remain silent, without such silence being a consideration in a determination of a guilt and innocence. Last is the to have the prosecution disclose to the defense evidence in its possession or control which it believes shows or tends to show the innocence of accused, or to mitigate the guilt of the accused, or which may affect the credibility of the prosecution evidence. Next part of this lecture is the confirmation of the charges before trial. Do suspects appear before the court as soon as they arrive in Hague? Yes, the suspect first appearance before the court takes place shortly after his or her arrival in Hague. During the first appearance, the pretrial chamber confirms the identity of the suspect, ensures that the suspect understands the charges, confirms that language in which proceedings should be conducted, and sets a date to begin the confirmation of the charges and hearing. At the confirmation of the charges hearing, which is not a trial but a pre-trial hearing, the prosecution must present sufficient evidence for the case to go to the trial. The suspect's defense may object to the charges, challenges the prosecution evidence, also or present evidence in his or her defense. The confirmation of the charges hearing is held in the presence of the prosecution, the persons being prosecuted, and his or her counsel, as well as the representative of the victims, as provided by the Article 61 of the Rome Statute. The suspect can waive his or her right to be present at his hearing. And what will happen after the confirmation of the charges? After the confirmation of the charges, the pre-trial chamber commits the case for trial, and trial chamber, which will conduct the subsequent phase of the proceedings. The trial, before the commencement of the trial, the judge of the trial chamber consider procedural issues that may be submitted to them by the parties, and hold hearings to prepare for trial and to resolve procedural matters in order to facilitate the fair and expeditious conduct of the proceedings. So, students, after the confirmation of the charge, the next stage is the trial. And the $1,000,000 question is that, okay, where does the trial take place? Trial take place at the seat of the court, which is situated in The Hague, unless the judges decide to hold the trial elsewhere. To hold the trial anywhere elsewhere, the part of the member countries of the statute. This issue has been raised in several cases. The accused must be present at his or her trial, which is held in public, unless the chamber determines that certain proceedings be conducted in closed session in order to protect the safety of the victims and witnesses, or the confidentiality of the sensitive evidentiary material. And what will happen after the start or any initiation or commencement of the trial? At the commencement of the trial chamber causes the charges against the accused to be read out to him or her, and ask whether he or she understands them. The chamber then asks the accused to make an admission of the guilt or to plead not guilty. And as usual in our normal trial, what will happen if the accused makes an admission or made any confession made by the accused of his guilt? Then first the trial chamber ensures that the accused understands the nature of the consequences of the admission or confession of the guilt, that the admission is voluntarily made by the accused without any without any under influence, coercive measure, threat, and after the sufficient consultation with his or her lawyer, and that the admission of the guilt is supported by the facts of the case that are contained in the evidence and charges brought by the prosecution and admitted by the accused. Where the trial chamber is satisfied that these conditions have been met, it may be convict the accused of the crime charge. If it is not satisfied that the condition have been met, the chamber shall consider the admission of the guilt as not having been made, in which case it shall order that the trial be continued and give the direction to prosecution to prove the guilt of the accused. And thereafter, if trial will be continued or accused will not admit his guilt, thereafter the trial will be conducted. And the trial, how is the trial will be conducted? At the trial, the prosecution and the counsel for the defense have the opportunity to present their case. The prosecution must present evidence to the court to prove that the accused person is guilty beyond all reasonable doubt. This evidence may be in the form of documents, other tangible objects, or witness statements. The prosecution must also disclose to the accused any evidence which may show that he or she is innocent. The prosecution presents its case first and calls witnesses to testify. When the prosecution has finished examining each witness, the counsel for the defense is giving the opportunity to also examine the witnesses and ask the question and as a cross-examine each witness. Once the prosecution has presented all its evidence, and it is the turn of the accused with the assistance of his or her counsel to present his or her defense. So thereafter, after the completion of that stage, then court will hear the counsels of the both parties, prosecution and defense, and thereafter announce the judgment and sentence. Once the parties have been presented their evidence, the prosecution and the defense are invited to make their closing arguments or statements. The defense, the defense always has the opportunity to speak last. The judges may order reparations to victims, including restitution, compensation, or rehabilitation. To this end, they may make an order directly against the convicted person. And when the sentence pronounced by the court, after hearing the victims and the witnesses called to testify by the prosecution and the defense and considering the evidence, the judge decides whether the accused person is guilty or not guilty. The sentence is pronounced in a public uh, and wherever possible in the presence of the accused and the victims or their legal representative, if they have taken part in the proceedings. And once judgment has been announced, sentence has been made, whatever the sentence as per their guilt, as per the severity nature of the crime committed by the suspect or accused, a court will pronounce or sentence the sentence pronounced by the court. Thereafter, the last stage, the last topic after this is topic. What will be the right of the parties? Appeals and revision. When may a decision be appealed? Any party may appeal the decision of a pre-trial or trial chamber. The prosecution may appeal against a conviction or acquittal on any of the following grounds: procedural error, error on fact, or error on law. The convicted person or the prosecution may also appeal on any other ground that affect the fairness or reliability of the proceedings or the decision. In appeal, the soundness of the decision of the pre-trial or trial chamber will be checked from all the corner of the laws. In a particular or on the ground disproportion between the sentence and the crime. The legal representative of the victims, the convicted person, or bona fide owner of the property adversely affected by an order and decision of the reparations to the victims may also appeal against such an order. The appeals chamber may reserve, sorry, the appeals chamber may reverse or amend the decision or conviction or order a new trial before a different trial chamber. Does the convicted person remain in custody pending an appeal? Unless otherwise ordered by the trial chamber, a convicted person remains in custody pending an appeal. However, in a general, when a convicted person's time in custody exceeds the sentence of the imprisonment imposed, the person is released. In addition, in the case of an acquittal, the accused is released immediately unless there are exceptional circumstances. Okay, students. Now we are now moving towards the our next topic, that is the ICC member states. ICC member states. There are 124 countries are state parties to the Rome Statute of the International Criminal Court. Out of them, 34 are African states, 19 are Asian Pacific states, 18 are from the Eastern Europe, and 28 are from the Latin American and Caribbean states, and 25 are from the Western European and other states. So alphabetically, these are the member states. There are 124, and who interprets the text of ICC statute. The rules of the interpretation derived from the Article 21 Statute of the Rome within the broader context of the rules set out by the Vienna Convention. That is the Article 31, 33. Thus, the ICC statute as an international treaty is subject to the VCLT Convention's rules of the treaty interpretation. So these are the Vienna Convention, the forum which interprets the text of the ICC statutes. Students, here's the conclusive and conclusion part of the our lecture. That is the two illustrative cases. Lord's Resistance Army Alare rebels case of Uganda, the Alare's leader Kone has been accused of ordering the abduction of the children to become child soldiers and sex slaves. 66,000 children become soldiers, 2 million people were displaced internally from the 1986 to 2009. The insurgencies also gave rise to the concentration campus in the northern Uganda where over 2 million people lived. Kone was indicted for war crimes and crimes against humanity by the ICC in 2005, but has evaded capture. The HRW reported that Colombia is among the 14 countries worldwide beyond the Central and West Africa that use child soldiers. In the cases of the Colombia, the report adds that the FARC have recruited children as a young as 7 and forced them into combat. They execute fighters who try to desert. There are no arrest warrants, no trials, and no conviction for the recruiters. So, anti-personnel landmines and other banned weapons are still being used by the FRC and the ELN HRV's World Report. This report has been reported in the HRV's Human Rights Watch World Report. And Lord's Resistance Army Alara Kone received a surge of attention in early March 2012 when a 30-minute documentary titled Kone 2012 by filmmaker Jensen Rossell for the camping group in Invisible Children Incorporated was released. So these are the YouTube links of that documentary, which is regarding the that Lord Resistance Army LRA Kone case. And next, Colombia ICC case. Here is the link of the Colombia ICC case regarding the same ICC jurisdiction and where ICC function. And ICC took actions against the atrocities or against the violation of the ICC statutes. So, students, I hope this final lecture regarding the ICC, which is very helpful, And next, my short lecture, I also will give you a very short lecture on the precise understanding of the selective brief introduction of the articles of the Rome Statute, which is the legal document regarding the court, International Criminal Court (ICC). So I hope these all lectures which I conducted on the ICC very helpful and give you I tried my best, because in a limited time there are a lot of cases, there are a lot of material, there are a lot of readings I can share with you, but in a limited time I give you all the very much important topics we have discussed in those lectures. And I hope further you will expand that knowledge with your hard work. Thank you very much, Isra.